Morning, my name is Hae-sun Kim. Today we will discuss about the Labor Standard Act Article 15 with Labor Attorney Jung Bong-soo, which state that labor contract contrary to this act. So could you explain about this article, please?
Hello, how are you today? This is Bong-soo Jung, Korean labor attorney. This article is so important in labor law. The reason is how we understand labor. This article show some two meanings. One is the employer violate this labor standard act. It is null and void. That means this is compulsory working condition, also meaning working condition. Also, the second one we can understand by this the article is that even though both parties agreed, so good faith principle cannot be acceptable in front of compulsory condition. So this article is so important in case of understanding labor dispute.
So do you mean that when an employer enter employment contract with the employee, and if they don't include such a condition as overtime or some other benefit, then it can, and if it's violate the Korea's Labor Standard Act, then it will be illegal.
Yes, even though both parties agreed, but the condition what they agreed is lower than the condition by the Labor Standard Act. They are invalid. Then invalid part will apply to the Labor Standard Act. This is what the article explains exactly. So in many applicable cases, we can see in actual labor cases, for example, there are minimum wage we have about 9,600 won. So for example, so if both parties agreed 8,000 for minimum wage because they are old or they are very young. So but such agreement mutually okay, but by law it is violation. Then labor, even though both parties agreed on the minimum wage, I mean the hourly wage per 8,000 per hour, but what they agreed is invalid. Then minimum wage 9,600 won is applied, even though they agreed. So this means compulsory condition is applied even though both parties agreed.
I see. So in such case, when the foreign invested companies in Korea, when they employ the workers, they may not be aware of these principles. So sometimes when there's inspection ongoing in the workers' environment, then those contracts that I have already entered can be invalid. So,
yes, that's right.
Yeah. So I think Korea Gangnam Labor Law Firm guidance is quite important and necessary for them. Do you agree?
Yeah. That's exactly. I fully agree with you, your explanation. So, for example, so the kind of reason for termination in the rules of employment or employment contract, like both parties, anytime, any reason, they can inform termination disagreement. Then in 30 days, this termination will be possible, is available. So this condition looks like okay because both parties agreed for condition for termination of the employment contract. But Labor Standard Act provide there should be just 5 reasons for termination. So employee can inform their termination in 30 days in advance. Then the contract can be terminated. But employee, in the case of employer, they should follow the just 5 reasons for termination. So without just 5 reasons for termination of employment contract, it is like unfair dismissal. Then employer should be responsible for this unfair dismissal. So this is what the labor law provide. So this article 15 of the Labor Standard Act, the condition that employee violate this Labor Standard Act, then such a party is invalid. Then invalid part will apply to the Labor Standard Act. This means this is really some exact guide for understanding labor issue. So, like a typical example is kind of severance pay. So severance pay is valid when they resign or they are terminated. But employer, so we have an annual salary system. So this severance pay is included. So 8.3% of total annual salary will be severance pay. So mutually agreed for this condition, but what they agreed is a violation of the Labor Standard Act, because severance pay is only valid when the employee resign, but employee pay in advance, that is a violation of labor law. Then such a violated condition is not valid in reality. So as a labor attorney, I always use this article, like Article 15, to explain to our client, especially foreign client, they don't know exactly about Korean labor law. Yeah.
I see. So in order to avoid any big fine, heavy fine, I think it's very important that they are aware of this Korea's Labor Standard Act. So Gangnam Labor Law Firm's advice is very helpful. Thank you very much.
Okay, thank you for watching. Bye bye.